Good morning, good afternoon, good evening, wherever you are in the world. Welcome to Mayer Brown's 10 Key Issues to Managing an Effective Supply Chain live webinar. My name is Alex Dale, and I'm a partner in Mayer Brown's London office. I lead the banking and finance group in London and co-lead the firm's supply chain and distribution group, together with Brad Peterson, Reg Gakey, and Angie Chia. We at Mayer Brown consider that supply chain and distribution has become one of the most systemically important issues that our clients are currently facing. This is not another COVID webinar, but we cannot escape the reality that this pandemic has significantly impacted the supply chain ecosystem around the world. We've all seen the headlines concerning the supply of PPE, testing equipment and medical devices such as ventilators, but beyond this sector, the impact of inflexible global supply chains have created an oversupply in some areas and shortages in others. In the US, for example, there is no coordinated effort for procurement and acquisition of supplies, and more generally around the world, there is no consistency regarding sourcing product and too few formalized industrial policies. Certain academics and commentators believe that supply chains are in chaos. We strongly believe that there are a whole range of value-driving issues that we believe are worth considering. It may be that you have encountered weaknesses in your supply or distribution contracts. It may be that the prospect of a weakened or insolvent supplier or distributor is keeping you awake at night. It may be that you worry about the prospect of litigation because of the dispute you're currently having with a counterparty. Whatever the issue, Mayer Brown has the team to help you. We are a global and integrated supply chain and distribution team comprising over 70 partners across the Americas, Europe, and Asia, with a diverse range of skills and experience which can help you navigate these issues and complexities. We're currently helping our clients with supply chain and distribution contracting, compliance, and disputes across the globe, helping them execute their strategies, navigate regulatory environments, and protect financial and reputational interests in the supply and distribution of goods, services, data, and technology. Today, we'll be highlighting the 10 issues which you can see on screen, which in discussion with many clients around the world have emerged as being highly relevant to supply chain and distribution. For many years now, supply chains have become increasingly sophisticated, in many cases highly efficient, operating on a just-in-time basis. And what was oftentimes taken for granted as simply working has now become a focus for many GCs, and in some cases, for the first time, a C-level issue, as real-time disputes consume time and attention, and strategic plans are being formulated to mitigate systemic risks. Whether the supply chain of which you are a participant or the supply chain which you finance, it is unlikely to have emerged wholly unaffected during this unprecedented period of disruption and dislocation. This is the first in a series of supply chain and distribution thought leadership programs that Mayer Brown will be hosting over the coming weeks and months. Together, we'll be highlighting the issues that we are seeing and will hopefully shine a light on how interconnected and oftentimes complex these issues can be. Joining me today as co-presenters are Angie Chia, who is a partner in our Singapore banking and finance practice, Reg Gakey, who is a partner in our Washington, D.C. litigation practice, Audrey Harris, who is a partner in our Washington, D.C. litigation practice, and co-chair of our global anti-corruption and FCPA practice, and Brad Peterson, who is a partner in our Chicago corporate practice. Well, with that said, let's get started. I'll turn over to Brad, who will kick things off with some insights into strengthening supplier and distribution relationships. Brad.
Thank you, Alex. We've all read a lot recently about the importance of strong relationships with suppliers and distributors. This isn't news, of course, to the people who run strategic sourcing arrangements and strategic alliances with distributors, but the COVID crisis, as Alex said, has made the value clear at every level of the company. Companies with strong supplier and distributor relationships have been more able to effectively adapt in this crisis as they have been able to effectively adapt in past crises. Relationships are, of course, between people and are built on a history of solving problems together for mutual benefit. The best relationships include people who truly understand both parties' businesses, have the management support, the talent, and the extensive personal connections needed to move rapidly. In those, there are regular meetings not only of operational teams, but of managers and executives, including, as Alex said, at the C-level. The ground is laid for successful collaborations. However, there's a considerable risk in relying merely on a good working relationship between good people. People move on. People form varying ideas on what is good faith compliance and what is a defection that needs to be punished. People forget the terms of the deal. And in some cases, people act opportunistically, breaching trust. So, the best relationships are built on a strong contractual foundation. And 4 components seem crucial for that. The first is accountability. The core goal in commercial contracts and supply chain and distribution contracts is to secure commitments to specified goods, services, or data at acceptable performance levels for a reasonably certain price. The performance standards might include those required for market success, for optimizing cost, or as we'll talk about later in this program, for legal compliance. To be actionable, the commitments must be measurable, auditable, and reasonable. And these commitments are fundamental to the success of the relationship. But leading companies go further. One way to go further is to create contractual incentives. These contractual incentives can reflect what the business team will call partnership and create a sense of partnership in that the parties are sharing the risks and rewards of a shared enterprise. With suppliers, it's common to, for example, reduce payments for late delivery or poor performance. With distributors, it's common to tie compensation to sales performance. With both, indemnities and limitations of liabilities are used to share risks and create a contractual incentive for joint work to maximize value and avoid costly pitfalls. Similarly, options provide leverage to both parties. Leading OEMs go further, including adding rights to do the equivalent of managing some of the operations of suppliers. Lisa Bernstein, a professor at the University of Chicago Law School, calls that managerial contracting. For example, if quality is impossible to determine once a product is complete, OEMs often set very specific production requirements, how an assembly line is set up, and send their engineers into supplier plants to verify the use of the exact methods needed. Similarly, services buyers insist that work is performed on customer systems using customer technology and customer security and so forth. The strength of this contractual foundation depends on the enforceability of those commitments, options, and incentives. Lawsuits with suppliers and distributors are rare, particularly in crucial relationships, but successful relationships are built both on provisions that require the right conversations, the governance clauses we call them, and a real option for third-party resolution. If the parties know that there is a real option for third-party dispute resolution, the parties resolve disputes based on how the third-party resolver would, most likely as they believe it, resolve the dispute. That's generally viewed as fair and builds the relationship. But if third-party resolution isn't an option, perhaps because the dispute resolution procedures in the contract are weak or inflexible or inapplicable, the parties are left without a clear standard for what's fair, and that can degrade the relationship. The value of a contractual foundation like this, with accountability, incentives, managerial contracting provisions, dispute resolution provisions, and so forth, that value depends on the investment made by the parties in contracting. Creating a firm foundation for the relationship requires a considerable investment by a multifunctional team. You need technical, operational, business, sourcing, and yes, legal skills to create that firm foundation. The best contracts are built with executive support and oversight of the formation and the governance of the relationship. And for novel, complex, and critical contracts, it requires a great deal of sophisticated effort to foresee and address problems like the ones we're having today with COVID. Again and again, though, and particularly as we've helped companies in these recent months review their contracts to see what they have in the COVID crisis, we have seen that the companies that have made that investment have stronger and higher value relationships. A strong relationship, of course, is only one part of a strong supply chain. And addressing contractual risk doesn't take you as far as you need when there are other types of risk, including financial risk. To discuss ways to address the financial risk in the supply chain, I'll now hand the program over to Angie Chia.
Thank you, Brad. Cross-border trade finance has always been complex, with title, property, and risk transfer issues as goods are transported from one jurisdiction to another, possibly involving different legal systems, and also possibly involving multimodal transport in international waters. Before supply chains got so interconnected, trade finance operated mainly with bank-intermediated structures to manage the competing financial interests of buyers and suppliers. Buyers wanting to make payment later, and suppliers wanting payment earlier. As supply chains evolved, buyers realized that in addition to the competing financial interests of buyers and suppliers, buyers had an interest in the financial standing of their suppliers. Because if their suppliers had cash flow issues or expensive financing, this would in turn affect their purchase and pricing, and then have knock-on effects for the entire ecosystem. Why is supply chain financing different from traditional trade finance and other working capital finance? Supply chain finance assesses risks not solely on the financial statements and creditworthiness of the borrower, but may involve other factors such as the criticality of the supplier in the supply chain. Financing is no longer necessarily reviewed on a bilateral basis, but has evolved with greater use of data and analytics to finance at different points in the physical supply chain. According to an article published in the Global Treasurer, I quote, "By some estimates, global supply chain finance volumes reached US $447.8 billion in 2016, marking a 36% increase from the previous year. Indeed, some estimates claim a year-on-year increase of up to 40%, although the rapid expansion is likely to level out at around 10% from 2020. Now, this article was written before COVID-19 impacted the world, and so some adjustment on the rate of increase will have to be made in light of this global pandemic. The role of AI, platforms, and other technology has been critical to the growth of supply chain finance. Whether it is used to analyze data or connect parties in the physical and financial supply chains, Brad will speak to that topic later on in this presentation. But as we consider the funding aspect, we also have to consider when it all breaks down. The impact of COVID-19 around the world has reminded us, firstly, how interconnected the world and supply chains are today. And secondly, how fragile those supply chains are. As many governments have installed support packages across the globe, we are not yet seeing the full impact of COVID-19 pandemic on suppliers and distributors. But what is clear is that the supply chain finance programs that are in place have appeared to be under less stress than the bilateral financings in place for smaller suppliers. Supply chain finance programs have assisted in shoring up the cash flow for these smaller suppliers, which are in some cases have been the difference between surviving and insolvency. But if the worst should happen, it is important to know how the different types of insolvency arrangements impact your suppliers and distributors. Would you be permitted to terminate the supply agreement? What if you have intellectual property which you have licensed to the supplier in place? Can payment terms be restructured? And if so, what is the impact on the restructuring? There are many issues to consider as supply chains are interconnected and fragmented. As we seek to address all these issues that can go wrong, may I hand it over to Rich to speak to potential and actual disputes. Rich?
Thank you, Angie. As Brad mentioned, and Angie as well, in any supply chain relationship and distributor relationship, there's always the potential for disputes to arise because, after all, people are involved. And while many of those disputes can be anticipated and addressed through clear contract drafting, sometimes, and in many relationships, those disputes often evolve in any event. Effectively managing those disputes, frankly, is critical to being able to maintain your supplier relationships over the long term, and that, in turn, is going to be critical to maintaining company margins. So we often work with clients to try to figure out ways to manage those disputes as they come up and to address ways to reform the agreements. Sometimes, particularly when an arrangement is going to be terminated, you'll end up ultimately needing to end up in arbitration or litigation. And in those cases, frankly, being able to seek early remedies is going to be one of your most particularly important strategies in those litigations. Now, on the supplier side, we see disputes in a number of areas. First of all, ensuring supplier continued performance. And these days, we see that particularly in the COVID space with questions around whether or not there's been a force majeure, how the force majeure clause works, or other common law rights regarding performance. But even before these recent events, we represented clients dealing with supplier threats, for example, to stop the supply of key parts in the automotive industry, or disputes regarding suppliers' breach of its exclusive supply agreements. The other area with respect to suppliers that we see disputes is around what I call substandard performance, which typically includes defective products, failure to live up to recall obligations, or failure to fulfill warranty obligations, which again we've seen in industries including auto manufacturing, food distribution, airline, and chemicals industries. On the distribution side, most of our litigation arises due to threatened or actual distributor terminations. As Brad noted, these relationships are often highly valuable to our clients, and you can imagine that when those arrangements are likely to be terminated, that the risks from litigation are substantial to both parties. So we see litigation involved in medical device industry, beer distributorships, apparel, food, oil, and gas, and a number of other industries. But beyond termination issues, in the distribution side, we see disputes arising related to pricing restrictions, geographic distribution, promotion or marketing obligations, brand ownership rights, and the levels of service and support that distributors must offer. Now, as Brad noted, one of the biggest challenges regarding these disputes is that the relationship itself is so critically important to the clients and is of such substantial value. Most of the time, by the time I get called in as a litigator, there's been a number of disputes that have already arisen between the parties, and one or both parties is trying to determine whether they may be better off by terminating the relationship. In that context, the legal issues typically quickly become intertwined with business questions, such as whether there's a substitute supplier that's available, whether or not the conduct arises to a material breach that would allow early termination, or whether there's a way to reform the arrangements to make it more sustainable. So the first part of our job is often helping clients to crystallize what their goals are. For clients who decide they don't want to terminate the relationship, we'll often be trying to leverage the kind of governance clauses that Brad mentioned in order to use those mechanisms to create a forum for bringing disputes to the surface. We'll then look to leverage contractual provisions to increase our client's negotiating position with respect to their supplier, and then marshal the evidence of non-performance to convince the supplier that it would lose in any ultimate dispute. And ultimately, through that process, hope to convince the supplier to agree with us to either revise the agreement if the agreement isn't working as it's intended, or to perform according to the terms of the agreement itself. I would note, as Brad noted, that contractual incentives, remedies short of termination, are often critical in this context, because if your only option is either to terminate the agreement or to sue for breach, an OEM may not feel like they have a whole lot of options available. So having something else that you can use as a lever is often critically important. Now, on the other hand, some breaches are too significant to negotiate over or too urgent to go through the normal dispute resolution process. And in those instances, having the availability of a TRO or preliminary injunction can be critical to actually resolving the issue and protecting your brand and your market position. For example, a number of years ago, we represented a manufacturer of medical devices who distributed their devices in the U.S. through a U.S. distributor. And as the term of that agreement was set to expire, it was clear to both parties that the agreement wasn't going to be renewed. So the distributor in that case set about trying to develop their own competing product in breach of the contract, and then to convert the market to the distributor's product before our client could get to market with a new distributor. So the distributor stockpiled product through false inventory reports. The distributor knocked off our client's product and sold it in response to orders for our client's product. And then when their own product was ready to be launched, they sold it and marketed it as an upgrade to their client's product. So we sued seeking preliminary injunctive relief. The court granted us an early trial on the merits, and not only did we put a stop to the distributor's conduct, but we also received an award of $150 million. So not only can effective dispute resolution capabilities preserve key relationships and protect margin, they can also help to protect the brand and your market position and compensate for injuries with the relationships when they terminate. So with that, I want to turn it back over to Brad to talk about business continuity and disaster recovery.
Thank you, Reg. The goal of business continuity and disaster recovery, or what we call BCDR, is to allow continuing operations at some level despite unexpected events, and ideally get to a rapid return to full capability even after a disaster. Reg just talked about some of the things that can go wrong if companies don't get back to full capability. There's a danger to the relationships, there's a danger to margins. So it's better, of course, to plan to recover from an event like COVID-19 or any other. Unfortunately, often contracts have the opposite effect. What they have is a force majeure clause that actually excuses performance due to unexpected events. And that means that you may find yourself in a position where your contract actually hurts you in terms of your primary goal of having two companies working together in a sort of a partnership to create value throughout the supply chain. In my experience, it's enormously difficult to get a good BCDR arrangement into a contract. When you're working with sourcing teams, doing strategic sourcing, category sourcing, whatever you're doing, there's a powerful incentive for the sourcing team to save money. Preparing for the worst costs money. Also, the team wants to get things done, and there's management pressure to get deals done, and identifying and mitigating the legal risks takes time. It also requires sophisticated technical, operational, and legal work, which again increases the investment. And often the issues that we discussed throughout this webinar, the 10 topics that Alex put up and we're walking through today, each must be considered if you're thinking about what that BCDR alternative is. Finally, while there are often key stakeholders for delivery, for performance, for quality, for price, there generally isn't a stakeholder in the room for reducing supply chain risk. And over the years that I've been working on this, what we see again and again is these, what we call, I love this term, black elephant events. The term black elephant was coined by environmentalist Adam Sweden, and obviously he was talking about environmental issues, but the idea is that a black elephant is a cross between a black swan, the unlikely event with large impacts, and the elephant in the room, the big risk that's so big that everyone knows about it, but no one wants to talk about it, or the big issue that no one wants to talk about. COVID-19 is a great example here. We all know that pandemics are a risk. We all learned early on about the Black Death and the 1918 flu pandemic that killed hundreds of millions. Recently, we've had SARS, HIV, H1N1, Zika, the avian flu, all of which could have been a lot worse. Governments have fought pandemics with quarantines for centuries. We've all seen movies about this. What we're seeing has been an elephant in the room for decades. And yet, many companies were thoroughly unprepared, and many are claiming that it's a black swan event. As Reg described, there's going to be a tremendous amount of litigation on these topics. So, what do you do to solve this? We think that C-level executives looking at these existential threats are going to be addressing these risks in 4 ways. First, specific BCDR provisions. Yes, it's an investment. Yes, it's hard. But when people look at the cost of the litigation, the lost production, the lost margin from not having been ready, we believe that people will be working hard to identify the risks, categorize them, decide how each will be addressed, and then make investments that pay off only in a disaster, much like buying insurance. Second, we think we'll see more dual sourcing. As Angie mentioned, there's a great deal of fragility in having a single path for sourcing. Yes, you save money with a sole source arrangement, but there's a great deal of fragility. And having 2 suppliers addresses the financial and geographic risks of the first supplier, however, of course, requiring the investments we talk about here. Third, risk-based financial analysis. When I work with deal teams on sourcing arrangements, I generally see savings being calculated based on the expected scenario, that is, without any low probability events happening. The results of that financial analysis change markedly in those leading companies who use risk-based financial analysis. For example, if you said, there's a 1% chance of a $100 million problem, a risk-based financial analysis would say it's worth $1 million to address that risk. Typical financial analysis would not identify that $1 million of potential value, so every dollar spent would look like a reduction in the business case. Obviously, most of the problems are much simpler. They're not million-dollar problems, and relatively small investments can make far better contracts with far better value, but it requires risk-based financial analysis. And that means that we need to have supply chain risk management as a stakeholder. As noted, nobody wants to talk about the elephants in the room. It's nobody's job. Nobody wants to hear about it. As lawyers, we do a form of supply chain risk management on legal topics like complying with IP and antitrust laws and being ready for litigation in bad situations, having the right commitments, options, and incentives. But ask yourself, who in the room is talking about those bigger risks, those black elephants today that, perhaps for others outside the room are black swans? Our partner, Audrey Harris, is one of those people who talks about those bigger risks, the risks that go beyond the business case.
Thanks so much, Brad. The global connectivity and impact of non-financial risks in the supply chain is increasing. We can see that from the presentation today. And no place is this more evident than in trade. What we have is a Venn diagram of political, regulatory, and commercial risk. They're actually overlapping and creating additional collateral risks. So with political risk, we're seeing the geopolitical impacts via ongoing trade and political uncertainties, in some cases exacerbated by the pandemic. For example, the ongoing increased U.S. and China trade tensions are a case study in how an emerging risk, in this case pandemic response, can add immediate trade volatility with direct impacts to your supply chain. With commercial risk, there's that renewed spotlight on the length and complexity of the global supply chains. And then there's regulatory risk, with regulation continuing to increase. Examples are plentiful, but they include such things as OFAC's recently released sanctions advisory for the maritime industry, energy, and metals sectors, as well as continued and increased CFIUS activity. So what does this mean in terms of a practical approach without creating unintended collateral risks? Well, one way we've approached this with our clients is through a whole risk approach lifecycle. So planning for non-financial risk like trade not in just a mitigation, litigation, and response posture, but also via proactive and preventative strategies. So proactive strategies, including, for example, using horizon scanning for emerging risks and legislation. As Brad pointed out, COVID-19 illustrated how many companies did not have pandemic in their line of sight, much less in their risk registers. And boards are asking, how do we see around that corner to the next unknown unknown? Looking around corners enables companies to start planning those alternatives into their forecasts for supply, incorporating these non-financial risks rather than just cost savings into supply function targets and incentives, and to think about proactive advocacy strategies with both government and other stakeholders. In addition, we also have preventative tools, especially in the compliance and operational processes. A key we're seeing here is structuring for short feedback loops and dynamic transition management in these processes. The leaders of Mayer Brown Trade and Government team have an integrated approach and a global capability set in this area, and they provide that proactive and preventative as well as the mitigation response strategies. We're also seeing this holistic approach bringing value in other compliance and corporate responsibility and ESG areas. Pre-COVID, the rise of the stakeholder, corporate responsibility, and reputational value had already created a trend of expansion, pulling these non-financial risks squarely into the corporate consciousness. First, the expansion of non-financial supply chain compliance risks from the more traditional subjects that we all know of AML, trade, and anti-bribery, where we were already seeing an increase in global coordination and enforcement, to a larger view of sustainability that also includes human rights, human capital, environmental, and community impact. For example, launched in 2000, the UN Global Compact currently has over 12,000 signatories in 160 countries. That's a 100% increase over the last 10 years. And the 24-hour news and social media continue to raise the stakes of reputational risk, increasing the need for companies to make an affirmative, proactive case for their businesses' continued social license to operate. According to a recent KPMG report, 93% of the top 250 largest global corporates now publish corporate citizenship reports. That's compared to only 35% 20 years ago. There's also an expansion of the stakeholders that corporations are now serving, as they move from serving the shareholder to serving multiple stakeholders, which include suppliers and communities. We are also seeing a broadening expectations for those you do business with, often deep into your supply chain, and government regimes are taking note. From the modern slavery acts, such as the UK and Australia, to the French duty of care law, and the recent EU directive introducing mandatory environmental and human rights due diligence, or even in the US with state legislation like Transparency in Supply Chains Act in California. This is where we're also seeing the commercial case for compliance and sustainability via customers and global brands who are passing these expectations into their supply chain, along with the audit requirements that go with it. And they're expanding the impact, as well as increasing others like banks and investors' requirements. This means, obviously, that supplier qualification is far from a time when it was just price, quality, and credit anymore. And going against what some predicted in the wake of COVID, it appears that corporate responsibility and sustainability expectations are actually continuing to rise in this environment, and that COVID-19 has become a case study in the value of a dynamic approach to non-financial risk. Part of this value we've seen in working with clients is quickly identifying the rapid changes in a company's risk profile, as well as the highest points of pressure in areas of potential loss of perspective in the supply chain that can result in decisions not aligned with the company's values, and applying strategic issue spotting, problem solving to mitigate the pressure, transparent and credible communication to bring renewed perspective, and strategies to increase resource impact. because at the same time that there's expanding expectations, there may also be a competition for resources due to furloughs and cost cutting. However, in this, there still exist opportunities to mitigate risk and actually grow value in your supply chain. We've been working with clients here to really focus on leverage of business reorganization, of commercial systems integration, of these non-financial risk areas, and of data cross-functionally to maximize resource impact. And we're applying what we call our map, align, and leverage strategies across these core risk areas. So where this increasing trend of holistic risk here can actually be an ally. The expansion of risk can be an ally as it identifies crossovers and advantages that can be leveraged. For example, strong anti-corruption programs can create great baselines and leverages for human rights compliance programs. And when companies start to map these different risks and align these non-financial risks holistically, they can have a better view of the risk landscape. They can close gaps, and they can address these new emerging risks, and often more efficiently and more effectively than before. Well, no holistic discussion of supply chain would be complete without a discussion of tax planning, especially in this global environment. So I'll turn it over to Alex to address this next in our supply chain top 10.
Thanks, Audrey. It would be fair to say that efficient supply chains are built in part on sound international tax planning. Supply chains invariably cross borders, and therefore care and attention to tax implications are necessary components to any sophisticated supplier or distributor of goods, services, data, or technology. COVID has forced multinationals to reassess tax planning, particularly if they are engaging in a strategic rethink with regard to their supply chain and distribution model. Anecdotally, certain clients have felt somewhat overexposed to a single origin of source in a single jurisdiction. Indeed, there is some degree of nervousness around over-reliance on China and, to some extent, India. In some cases, there's even an ongoing blame narrative directed towards China, which may benefit smaller regional competitors such as Vietnam, Taiwan, and Bangladesh. Whether you're thinking of pivoting away from your current origin of supply, or diversifying to create multiple origins of supply, or even reshoring back to your home jurisdiction, tax planning is inevitably an integral component. Is transfer pricing consistent with evolving functionality? How are you allocating costs among members of a multinational from a tax and transfer pricing standpoint? Does the international structure that you have still work in the light of employee dislocation? Given stay-at-home orders and remote working generally, staff undertaking different responsibilities, possibly in different jurisdictions than pre-crisis, may be creating unintended tax consequences. Could the roles being conducted whilst working from home and thereafter as part of return to office arrangements actually be breaching tax residency rules? The old adage that a crisis is a terrible thing to waste comes to mind, and you may wish to consider whether there are opportunities to improve your tax structure in the light of depressed values and margins. Every multinational is engaged in crisis management, and every internal tax team should absolutely be an integral part of that crisis management team. Suffice to say that we have a leading global tax practice at Mayer Brown, and should your in-house tax team need to bounce ideas or otherwise test their analysis with our tax colleagues, they would only be too happy to assist. And now I'd like to turn over to Reg to discuss the protection of intellectual property rights. Reg.
Thanks, Alex. Protecting a company's IP rights is typically a critical issue in the supply chain context. In setting up new suppliers or distributors, companies need to consider how to protect the IP that they're bringing to the arrangement, particularly in international arrangements, how to ensure that they're obtaining sufficient rights to the IP that the supplier creates, and how to address IP that's generated in the course of supply arrangement. And consideration also needs to be given to the extent to which each party can compete outside of the relationship. Now, the particulars of these analyses differ based on the nature of the IP itself. So, for example, in the patent context, licensing may often seem fairly straightforward, but when you do so across multiple jurisdictions or where there are multiple patents that are at issue, there are many traps for the unwary. For example, we recently represented a client in the context of an acquisition where it was very clear that our client held the patent rights to the manufacture of the particular product, but it was not clear that the client had gotten back the grant back of the rights that the supplier was using on know-how and any improvements in the context of the manufacture of that product, and that became a real issue in the acquisition. So anticipating those sort of issues in your license process itself is an important thing to think through. A second key topic is in the trade secrets context. Trade secrets are often so confidential that many clients won't even, in fact, license the supplier to manufacture products that are where trade secrets are critical to the relationship. But where you do, it is critical to protect the confidentiality of that trade secret. A number of years ago, we represented an industrial steam generation company against its supplier licensee who intended to stop paying license fees and start competing with our client. The licensee contended that the trade secrets had all become public. Now, we were able to succeed after a year of arbitration to obtain a favorable settlement. During the course of that litigation, we realized that a substantial number of our clients' trade secrets had been published, both by our client and by ourselves, by our client and by the licensee. Now, many courts these days expect trade secrets to be identified by the parties and to be separated from the usual course of conduct, and in that context to be given particular protections. So agreements need to anticipate this and require adequate confidentiality, including physical and electronic security, as well as audit rights to make sure that those steps are actually being enforced. Now, third critical IP right, particularly with respect to distributors, is the trademark right. Trademark rights are critical to protecting a company's brand as well as to protect their position in the marketplace. A great example of this and how the enforcement of trademark rights can help to protect a brand is an action we recently brought on behalf of our client 3M, who sued one of its distributors of face masks under the Lanham Act for price gouging. By bringing that somewhat novel action under the Lanham Act, we were able to obtain a preliminary injunction and to stop that price gouging. So that's a good example of how trademarks can be used to protect your brand in the marketplace. A fourth area to consider in the IP context is to make sure that the suppliers hold and transfer all necessary IP rights to you as the manufacturer. This is particularly important where the supplier is designing their own parts. And there's a risk that the supplier may use a third party's IP and the OEM would become liable for that. And so this risk is typically addressed through IP indemnity provisions. Now, in addition to reviewing contracts and helping to set up those contracts to protect your IP rights, the other thing that we do and that is very important is being creative about the enforcement of those IP rights, because the IP rights are only as good as the enforcement mechanisms themselves. So, for example, we've recently represented a food manufacturer and pharmaceutical manufacturer in actions to curtail importation of gray market goods. This is a place where products are being designed and sold and licensed, for example, to be used in one market, such as Mexico, but then they're sold into another market, such as the U.S., where they compete with the products that are being distributed there. Taking action in such circumstances is not only important to protect the brand, but also to ensure compliance with local laws. Another enforcement option that one should consider in this context is bringing an action at the ITC, the International Trade Commission, under Section 337. That act allows the ITC to determine, typically through a very expedited process, whether the imported goods infringe a patent or violate a trademark, and provide an automatic enforcement mechanism where the U.S. Border and Customs Control becomes your enforcer. So this is another creative option that clients have considered to protect their IP rights. Again, considering and using those creative options for enforcement, either in the 3M type of action, the gray market goods, or in the 337 proceeding is critical to enforcing your IP rights and protecting your brand overall. Now I want to turn to a related topic, which is the antitrust issues. Antitrust issues often come up in the context of supplier-distributor relationships, more often on the distributor side. And we often help clients to anticipate those issues, both as they're forming their relationships and as the relationships continue on. On the supplier side, we often see issues arise when when manufacturers form joint ventures with their suppliers. For example, joint ventures for the development of batteries, or joint ventures to optimize sourcing for chemical products. And a key issue is, even though you may be setting up a joint venture, for example, only in the U.S., those joint ventures can trigger merger control filings around the globe in terms of multiple jurisdictions where you need to file those. On the distributor side, issues can become even more significant from an antitrust perspective. Obviously, if you enter into exclusive or preferential purchase or supply agreements, this can trigger antitrust scrutiny, particularly where one of the parties has market power. A related issue is where there's potential for retail price maintenance. While retail price maintenance in the U.S. Is no longer per se illegal under a Supreme Court decision called Legion, many states consider it still per se illegal, and the U.S. and the EU also looks at it skeptically. So in order to address those types of issues, many companies will instead look to the minimum advertised prices as a way to help to manage the pricing through their distributor relationships. And this helps to control the quality and the level of services that your distributors are providing, and addresses what we refer to as showrooming, where customers will come into a distributor, look at the product, and then buy it online. Now, minimum advertised prices by themselves don't violate the law, but they can raise antitrust issues depending on how they're implemented. And there's great variation in terms of how courts treat those issues. So the key issue from the supplier's perspective is to make sure that the retailer retains the right to determine the resale price. And this, again, often turns on particular factual matters. What is said, if anything, in the agreement on the topic, whether or not it appears that you're compelling a price at a particular sales price, and whether or not your minimum advertising price policies are being shared with competitors. Finally, many companies address these minimum advertised price issues through the allocation of trade spend in order to give distributors a carrot to follow those pricing controls. But again, for the same reasons, those spend issues can also lead to antitrust issues depending upon the facts. So we often work closely with clients not only on setting up the agreements, but also in terms of how they set up the facts, how they enforce, and what practices they actually use to make sure that those practices don't run afoul of antitrust issues. And this is particularly important, for example, with respect to online retailers, where the advertised price can quickly become the minimum price. And in the context of complex algorithmic pricing, where issues can arise under the Robinson-Patman Act with respect to price discrimination. So not only do we work with clients on the front end in structuring the agreements, but as I said before, we also work in implementing minimum advertised pricing policies and in training personnel to be consider the compliance and make sure that they're doing the steps they need to do to actually comply with the antitrust laws. In addition, if issues actually do arise with respect to either regulators or litigation, we'll represent our clients in those contexts. Many of our partners have substantial experience and relationships with government regulators, which allow us to help address those potential investigations early and to articulate to those regulators the important pro-competitive effects of the client's policies. When litigation does arise, Mayor Brown has represented clients in some of the highest profile antitrust cases go to the Supreme Court, including the Twombly case, which really set the standard for evaluating claims at the motion to dismiss. So we're very good at helping clients to position themselves to get antitrust claims dismissed early. Now with that, I want to turn it over to Brad to discuss our last topic, which is AI platforms and technology.
At this point in the presentation, it's hard not to feel a little overwhelmed by the number of things to keep track of and the number of factors and the number of things that are worth paying attention to in the areas of supply chain and distribution. And it's fortunate that we're in a tremendous convergence of technologies. We're seeing artificial intelligence, robotic process automation, cloud and other as-a-service technologies, and more specifically to supply chain and logistics, we're seeing connected and autonomous vehicles. We're seeing telematics as a way to track products and track trucks and so forth, where they are. There are two things to consider here. First, every company has not just a goods supply chain, but also a technology, data, and services supply chain. And the services supply chain for many companies is far greater than the goods supply chain. The data supply chain is absolutely critical in many industries and growing more critical. So when you're thinking about these supply chain issues, it's worth thinking more broadly about them, because those relationships will be critical also. Second, it's worth considering how these technologies will be transforming supply chain for the future. We're increasingly seeing artificial intelligence in supply chain management systems, allowing a new level of efficiency and the ability to deal with a new level of complexity. That's worth leveraging to solve some of the problems that we've discussed. We're seeing companies leveraging revenue-driving digital platforms, and those are in some ways disrupting or affecting distributor relationships. During this COVID crisis, we've all, and as consumers, of course, done considerably more of our buying on revenue-driving digital platforms. We see this as a tremendously disruptive trend in supply chain. And then there's we've all seen the pictures of the automated factories, the warehouses, the distribution centers, and vehicles. These too will be transformative. There are some key challenges here, and part of it is what we've been talking about all the way through. How do you contract for something which is so new that we haven't begun to see it yet? How do you address the changes which are rapidly happening to existing contracts and existing modes of operation? And how do you affect the way those changes in technology will be disrupting the lives of people who rely on supply chains for their lives and so forth? When we talk about moving supply chains for tax reasons, for example, those supply chains are built on people. Regulation. The regulators, as we all know, years ago were paying little attention to technology. Increasingly, regulators are seeing technology not only as an opportunity to collect the data that's necessary for proper regulation, but also as an opportunity to more effectively drill in and understand exactly what violations may be happening in the supply chain. It's well worth putting additional emphasis on when you are working to leverage AI platforms and other technologies, focusing on the regulatory impact. And finally, the technology can be what the technology providers call sticky, difficult to move away from, and that means that you may find yourself with an unexpected reliance on a technology or technology provider. These things can be addressed through planning, through business continuity and disaster recovery, and through all the steps that we've talked about in this webinar today. And with that, let me hand it over to Alex to wrap up our program. Alex?
Thank you, Brad. I think we may just have time for one question. I promised that we would deal with one if we had time. So very quickly, we've had a question come in from Damien Booker from the International Chamber of Commerce. How should companies deal with the prospects of governments pushing for a reshoring of jobs and supply chains? Brad, are you best placed to pick that one up?
Oh, sure, I'd be happy to talk about that. This is a great question because reshoring of jobs and supply chain has all of the implications that we've talked about today. It involves, depending on your geography, it involves geographic risk, financial risk, compliance risks, and what Audrey was talking about is non-financial risks. And if you think about it, to do reshoring is not just a project, it's a program. And you will need new and strengthened supplier and distributor relationships. You'll need to look at your new suppliers and distributors, the reshored suppliers and distributors, and make sure that they are financially sound. You'll need to address disputes with the suppliers and distributors that you may be moving away from in the offshore jurisdiction. It's time to think about some of those bigger issues that we've talked about, the trade, customs, and other regulations. You're switching from being an importer to being an exporter with a new set of rules. You are switching from production in one country to production in another. Your tax strategy, which was built on the offshore investments and the offshore production, now becomes perhaps irrelevant, and you need to redo your tax strategy. The protections you had for intellectual property rights in the countries where you were doing your production or distribution may now be irrelevant because intellectual property rights are inherently national. You may have new issues with antitrust and competition laws. This is, as Audrey said, there's an expansion of risk can be an ally, and a better view of the risk landscape allows you to step back and develop programs and well-considered approaches to issues like business continuity and disaster recovery, and addressing the legal, compliance, and contractual issues that come up in a complex change like reshoring a supply chain. Alex, anyone else would like to contribute to that?
Well, I think we're running out of time a little bit. I'm just conscious of everyone's time, or we've got to the top of the hour. We've had a bunch of other questions. I'm sorry we haven't been able to come to you, but we will circle up after this as promised. I'd just like to thank my fellow speakers today, but more importantly, I'd like to thank all of you who have joined us on this particular webinar. As I mentioned, the Mayer Brown Supply Chain and Distribution team comprises over 70 partners around the world, and we believe that we are probably the only law firm that has a global integrated team operating in this space with that kind of volume of committed resource and bench strength. As the legal and regulatory issues you've heard today are invariably interconnected and complex, we can be a sounding board for you to support your legal and executive management teams navigate what are undoubtedly choppy waters. You are more than welcome to reach out to any of us directly or through our website on the slide searching supply chain, and we'd be happy to discuss your issues or concerns, bringing together experts best placed to assist. And with that, I'll conclude today's webinar. Please do watch out for further invites to webinars or podcasts in the coming weeks and months as we dive a bit more deeply into the subject matter highlighted today. In particular, we'll be looking more closely at financial, geographical, contractual, and compliance and reputational risk. Many thanks for joining us again, and we look forward to welcoming you back soon.